In this video, we're going to talk about navigating misdemeanor cases in Marshall County, Indiana. About me, my name's Nathan Vining. I'm a criminal defense attorney here in Indiana, and I'm going to walk you through what you can expect if you've been arrested in Marshall County, what the case process looks like, and how you can navigate a misdemeanor case in that county. So the first thing you look at is why you came in contact with the law enforcement. You're going to want to see, did the officers have a reason to pull you over, or if you weren't in a vehicle, why did they contact you? Did they have reasonable suspicion that there was some crime occurring? From there, if there were any searches or things like that, or evidence obtained against you, you're going to see, did they have a reason to search your vehicle, your person, your house, things like that. Was it evidence that they collected? Was it obtained in legally permissible ways? From there, if you were arrested and they took statements against you, or even before you were arrested, did they get statements against you? You're going to look to see if your rights were violated in obtaining any statements from you. So that involves your Miranda rights. So here with the arrest, really you want to scrutinize why you came in contact with police officers. Was the evidence obtained against you done legally? And then any statements made, were those statements legally obtained? So that's really what you look at with an arrest in Marshall County. From there, if you are arrested, you're going to consider bail. Bail is the amount of money that ensures that you appear in court in the future. Sometimes the court may release you on your own recognizance. Other times they may set a bail amount. Sometimes it can be a low amount. Typically it would be a low amount for a misdemeanor case. And essentially it's an amount that's designed to make sure that you appear in court in the future. If bail has been set too high, you can move to reduce it. That's something that you would work with an attorney to do, to argue why it should be lower. It could be you have certain contacts in the community, you've lived there a long time, you're not a flight risk, you have no history of missing court dates, things like that. So bail is something you're going to want to talk to an attorney if you can't post it, and it's something that you have a right to unless it's a murder or treason charge. So if you're charged with a misdemeanor, you have a right to bail in Indiana. The next thing you want to know is when your court dates are, where the court is, and when your next court date is. So here's the Marshall County Courthouse. It's located just downtown Plymouth. You would go in this door in the annex. You would ask where you're going because there's a couple different courtrooms and they're in very different areas. So you want to make sure you go to the right place and you know where you need to go. So go in there, check in, and let them know where your case is located. It's going to be something that sounds like Superior Court 1, Superior Court 2, Circuit Court. So you're going to want to know which court designation it is so they can send you to the right place. From there, you also need to know your court dates. It's pretty obvious, but what may not be obvious is that there's a website here in Indiana. It's mycase.in.gov. You can go in there, and here's a screenshot of it. You can search your case by your last name and see exactly when the next court date is. It also shows filings in the case, the dates, things that were filed, and all sorts of information. So it's a very useful website to know. So if you have been arrested and you're facing a court date, go to mycase.in.gov and keep updated on what's going on in your case. The first hearing in a criminal case is known as the initial hearing. This is a hearing that's held at the start of the case. It's where the judge reads your rights, things like the right to remain silent, the right to confront and cross-examine any witnesses, the right to a jury trial, things like that. They also go over what you've been charged with. So they're going to review what are the charges against you, the level of the charges, the potential penalties, and make sure that you're basically apprised of your rights as well as why you've been charged. And then they can discuss whether or not you need a public defender or want to hire an attorney, things like that. So the initial hearing is the first hearing in the case, and that kind of kicks things off. And then they set further court dates from there. There's also discovery in a criminal case. This is where you get to see the state's evidence against you. The state will have to show you what they've collected, who they plan on calling as witnesses, do they have any witness statements, things like that. You also could go out and get your own evidence. Do you have witnesses that would be beneficial? Do you believe there's video from around the scene that could be beneficial? Things like that. So you're going to want to take part in the discovery process. You're going to want to not just sit back and hope your attorney handles it. You're going to want to take a look at everything yourself because your attorney wasn't there. They need you looking at these things so you can help advise whether or not there's issues or additional things that are needed. The next part is pretrial motions. There are a lot of different motions that can be relevant in a criminal case. Things like a motion to suppress, which would exclude illegally obtained evidence. There can be things like a speedy trial request. If you're in custody, you can request a speedy trial. There's also certain defenses that you may need to affirmatively plead, like a notice of an alibi, notice of self-defense. So there's a lot of pretrial motions that are relevant. You're going to want to work with your attorney to make sure you don't miss any deadlines and that you have all the proper pretrial motions filed. There's also what's known as pretrial conferences. This is an opportunity to discuss the case. They're a lot less formal than what a trial is. It's really a meeting with your attorney and the prosecutor to help keep the case moving forward. These prosecutors have hundreds, sometimes even thousands of cases, and sometimes it takes tracking them down in person to help get things done in the case. And this pretrial conference is a meeting that happens every month to 2 months. It's the opportunity for that in-person meeting to make sure the case is moving forward. You discuss discovery issues, you do plea negotiations, and then you just resolve outstanding issues. So pretrial conferences are typically very informal in Marshall County. And in Marshall County, it's a meeting with your attorney and the prosecutor that happens typically in the jury room of the courthouse, where they discuss your case and keep things moving forward. And then you leave that meeting with either a trial date, a plea hearing date, or another pretrial conference date, so you can come back and continue negotiation. There's a couple ways to resolve a case. One of those is through plea agreements. A plea agreement is a plea to some set of charges. It can be the charge you're charged with, it could be a lesser charge, or it could be something else. And it's an agreement with the state where you're agreeing to what the outcome would be. A lot of times it would be a plea to a lesser charge in probation or something like that. A lot of times it means that they're getting a plea, but you would be getting some kind of lesser sentence or a set sentence that you would be happy with that is in exchange for this agreement to plead guilty. And it's a set outcome rather than the risk of trial. So plea agreements are something that are involved in a lot of cases. It's something that we would talk about if we're involved in a case. But there's also, rather than taking a plea agreement, you have the right to a trial. And if there's no evidence or there's evidentiary issues or things going on in your case, you also have that right to a trial. That's important too. And that's something that we do pursue a lot in a lot of cases as well. Outside of plea agreements, there's also pretrial diversions, which is a good way to resolve a misdemeanor case. A pretrial diversion is an agreement with you and the prosecutor where you come up with an agreement to stay out of trouble for a set period, pay a user fee to enter the program, and sometimes there's some other parameters, do some community service, do some sort of class, things like that. But ultimately, a pretrial diversion is an agreement where if you stay out of trouble and complete these terms, the state will dismiss the case, and that's a great outcome because if you can get the case dismissed, you can then expunge it and it's like it never happened. So pretrial diversions are a good, predictable way to achieve a dismissal in a misdemeanor case. If you can't get a plea agreement that you're happy with or pretrial diversion, there's also the opportunity for a criminal trial. Here, the criminal trial is where the state has the burden to prove the case against you beyond a reasonable doubt. So they would go through and present the evidence, call the witnesses, so you would be able to cross-examine them, then present evidence of your own if that's what you want to do. And that's where you would do that with a jury or a judge. With the jury in a misdemeanor case, you do have certain time requirements on when you request a jury trial, so you want to make sure you don't miss those. But also you can present the case to a judge, and the judge then would decide is this person guilty or not guilty of one, some, or some lesser crime. If you plead guilty or convicted at trial, there would be a sentencing date. This is typically held within 30 days of the guilty plea or trial. And what this is an opportunity for you to argue what the outcome should be. So you can offer what's known as mitigating evidence. So you can say, I was convicted, but X, Y, and Z are reasons why the court should be lenient with me. They can be things like things you've been doing since you've been arrested. Maybe you've done substance abuse classes. Maybe you've done anger management. Maybe you now have a job and your life circumstances are different. Sentencing is an opportunity to explain to the judge what should happen in your case and why. It's a very good opportunity for you to explain to the court why the outcome you want should happen. If you have questions, give me a call. I do cases in Marshall County. Would be happy to talk to you about what I think about the case, what you could be doing, and what we can do for you. Thanks for watching. Here's my number, call or text. Thank you.